Hi, my name is Sloan Lambert, and I'm one of our attorneys here at Malone Hatley PC. Family law cases can be emotional, they can be confusing, and they can be full of legal complexities. Whether you're dealing with a divorce, a custody dispute, or a support dispute, not knowing your rights can severely cost you. Today in this video, we will be talking about 3 different kinds of cases and various facts that a lot of people don't actually know that they have when it comes to rights within those cases. Those are going to be divorce, child custody, and support disputes. Family law cases can be emotional, they can be confusing, and they can be full of legal complexities. The first kind of case we'll be discussing is divorce. Many people enter divorce proceedings unprepared, and that leads to them signing agreements that are not in their best interest or not actually knowing where their assets are going to go upon equitable distribution. Equitable distribution is Virginia's process of dividing marital property. Marital property is any property that technically is tied to both spouses during the marriage, as compared to separate property like inheritance or gifts that stays with only one spouse after the marriage ends. Many people enter divorce proceedings not knowing their rights, and that can often lead to unfair settlements or loss of financial security. The first fact is that you have a say in equitable distribution. There is a presumption that all marital property is going to get just divided right down the middle 50-50, but that's not the case in Virginia. Equitable distribution is just what it sounds like. Whatever is fair for the parties is how everything will be divided. And if you sign a settlement agreement, then you can actually decide how that division actually occurs. The second fact about divorce is that you might be entitled to spousal support. And while spousal support, or commonly referred to as alimony, it's not automatic. If there is one higher earning spouse and a lower earning spouse really depends on that higher earning spouse's income to support their lifestyle, then the court will often look at that and provide spousal support to the lower earning spouse to make sure that the standard of living is not drastically affected by the divorce. And lastly, the third fact is that any hidden assets will be legally discovered. If you think that your spouse might be hiding a bank account somewhere or hiding money somewhere that actually would affect a spousal support arrangement, for example, definitely let your attorney know, because your attorney can use someone called a forensic accountant to find assets like that to make sure that that division is as equitable and as fair as Virginia wants it to be. The next 2 types of cases that we'll be discussing are custody cases and support cases, including child support and spousal support. Child custody and child support cases are some of the most emotionally charged cases in family law. Not knowing your rights can not only affect your relationship with your spouse, but also with your child. Knowing your rights is crucial to make sure that you remain in the best interest of your child. The first we're going to be talking about is custody, and that's, of course, who will have the most time or equal time with their child upon divorce. The first fact is that while there's a presumption that the court will favor one parent over the other, that's not the case. There's a presumption that courts will always favor the mother when it comes to custody arrangements. Fathers are looked at in the same degree as mothers are when it comes to fairness and what the best interest of the child is in the actual division when it comes to custody. That is the standard best interest of the child. The next fact is that child support is not just a random number that attorneys sometimes make up. There are Virginia child support guidelines and spousal support guidelines that actually determine how much spousal support or child support is fair in a given situation. Not only is it based on parties' income, but when it comes to custody and child support, parenting time is looked at the same way. If there's one parent that's considered the custodial parent, or the one who is just mostly around the child, then a lot of times the non-custodial parent will pay child support to the custodial parent to help upkeep of the child, whether that be medicine if they're sick, groceries, or something like that. All of that is put into those guidelines to make sure that, again, the child is actually taken care of. The third and final fact that we'll be discussing for support is that support arrangements can be modified. So if you are paying or receiving child support and your situation changes and there's been a material change in circumstance, say that your income is cut by half and you're no longer able to afford that much, or you want to see your child a bit more and there's been a material change in circumstances, like you've moved closer to the child and therefore can see them more often. These are things that can be modified. So definitely contact your attorney to see if there's a way that you can open the case back up if there's been a material change in circumstance that would result in a change. Just to reiterate, family law is complex, and it's full of those legal complexities that can sometimes be confusing. And the last thing that we would want is for you to be caught up in a situation that is not the best interest of you or for your child. So contact us here at Malone Hatley PC, your partner in divorce and estate planning, to find out what your rights are in divorce, child custody, or support today.